Hello, esteemed participants of IMCCRT 2022. I am going to present abstract of paper titled Investigation on Effective Procedural Law Based on Crime, Criminal Acts and Criminal Suspects. Myself, Kafi Mahmud. I am a research scholar in Chandigarh University. Uh, According to the basic principle of law, anyone should be considered innocent in law before finding himself guilty by the court. The principle of presumption of innocence is mainly manifested in two aspects. Firstly, the accusing party takes the burden of proof. Secondly, it protects the fundamental rights of citizens, especially those suspected of crimes, rights of persons and defendants. This research will explore how the state initiates criminal prosecution based on criminal suspicion regarding the basic principle of presumption of innocence. Also, this article illustrates the difference between criminal suspicion and criminal facts, conducts a conceptual analysis of criminal suspicion and discusses the classification and proof of crime suspicion to describe the three main types of criminal suspicion manifested in procedural law. In a modern society ruled by law, conviction is the only way the state may punish a person. Conviction is a negative evaluation and conclusion made by every country on the individual as a member of law. The direct consequence of conviction is generally that the state imposes particular penalty on the offender according to the law, leading to the freedom, property, and loss of life, which are fundamental human rights or basic rights. Conviction is the most severe violation of the rights of citizens by state power. This violation must meet two essential conditions. The accusing agency has sufficient evidence to prove that the person has committed a crime prohibited by the law. The judge adopts this evidence and meets the standard of proof, which is sufficient for the judge to find that the person is legally criminally responsible. The conviction must be made by a neutral judge through lawful and due process in an open and impartial setting. According to this, no other state organ or individual has the right to convict. Before the court convict anyone, the accused person is legally innocent and enjoys enjoys the right to defend himself before the court legally. The value of the presumption of innocence is to preserve the subject of every citizen facing public power. If the government wants to take coercive measure such as restricting personal freedom and infringing on property rights against a free man, it must provide legal and reasonable reasons. Even if a free man has become a criminal suspect, he can still reasonably expect his right. He will be effectively protected by the legal process and remain legally unbounded until a court finally establishes his guilt. If he desires, he can use all the lawful means to fight with the authority until the court makes a final judgment following the law. Therefore, in the stages of the investigation, prosecution, and trial, those involved in criminal proceedings are only citizens suspected of a crime and have not been yet identified as criminals. Just because there is only suspicion of crime, the government cannot mix this suspicion. It is impossible to suspect someone of a crime without any basis and make them a criminal suspect. In the Indian subcontinent, current criminal procedural law does not distinguish between criminal suspects and criminal facts, and the concepts of criminal suspects may many researchers from home and abroad use these concepts confusingly. Criminal suspects should be filed for investigation following the jurisdiction to collect criminal evidence and seize criminals. Investigators may investigate the body and articles of criminal suspects and persons who may be criminals or has criminal evidence in residence and other related places. It is still the case at the legislative level and in judicial practice. There is a bounded presumption that the party is there, and there is never a presumption of innocence. The suppose anyone cannot accurately understand the nature of criminal suspicion. In that case, anyone cannot abide by the principle of presumption of innocence and cannot implement the protection of the human rights of criminal suspects. The purpose of this research is to analyze the concept, nature, and classification of criminal suspects and their effects on procedural law, to establish the theory of presumption of innocence in legislation and resolve the view of presumption of innocence. So, make it into concrete legislation and judicial practice. Let it play its due role in criminal proceedings and effectively protect the rights of criminal suspects and defendants. Firstly, the concept of criminal suspect has been defined to understand the crime that endangers society and should be punished according to the law. Secondly, the identification and proof of criminal suspect are investigated based on investigative procedural organs and whether the um, presumptions about the crime and perpetrator are correct. Finally, the effect of the criminal suspect in the procedural law has been observed for a free citizen turning from a native person to a criminal is that he has a criminal suspicion and investigation and the prosecution agency suspects that he has committed a crime. The research has practical implications in the principle of presumption of innocence. It effectively protects the lawsuit of criminal suspects and defendants only by clarifying the difference between criminal suspects and criminal facts, but also between criminal suspects and criminals at the legislative level and in judicial practice. Judgment criteria for a real criminal. First of all, the procuratorial organ's suspicion of a crime is based on its judgment and is not subject to the investigation organ's judgment on the suspect. The procuratorial organs should be carefully examine the basis of criminal suspects and only through the examination believes that there is a real criminal suspicion. In future trials, this evidence is sufficient to contradict the presumption of innocence and believe that the judge will make a guilty verdict based on this evidence to file an indictment. Secondly, many factors need to be considered whether a real mm, criminal suspicion is established. The most important of which are the following levels. First, whether the evidence of a suspected crime can be used in court, means whether the evidence has evidential capacity or not. Suppose the judge may exclude the evidence because the collection method of this evidence is illegal, or the law prohibits the said evidence's use in a case. In such scenario, the prosecutor's expectation of conviction may no longer be established, and the determination of a definite criminal suspicion cannot be formed. Second, whether the evidence on which the crime is suspected is reliable or not. That is what is the probate force. It is possible for the judge to believe that the defendant has indeed committed the alleged crime beyond a reasonable doubt. When measuring the reliability of the suspect, such a general formula can be used. Finally, the prosecutor has the discretion to prosecute a case. This power of prosecution does not mean that the prosecutor can determine whether to prosecute a case according to the degree of criminal suspicion. The basis of prosecution discretion is that the criminal suspect has reached the standard of prosecution, which means the prosecutor believes there is a real criminal suspicion. But according to other considerations, such as paralysis, it can be determined not to prosecute. Suppose the prosecutor's suspicion of a crime does not reach a real criminal suspicion level. In that case, the prosecutor's only option is not to prosecute, and there is no room to be planted. If the prosecutor's suspicion of the crime has not reached a certain level, he is not sure that the judge will make a guilt sentence or not. Under such circumstances, deciding to prosecute is an illegal act that violates the criminal suspect's basic rights. Suppose the defendant is acquitted by the court or ruled back to prosecute. In that case, he can sue the prosecutor for malicious prosecution, pursue legal responsibility for infringement or abuse of power, and demand compensation from the state. The fairness of the lawsuit and prevent the ambush trial. The so-called ambush trial means that one party to the suit has particular key evidence and the other party is at a loss. To prevent an ambush trial, in the judicial review of public prosecution standards, both parties participate together to understand each other's evidence and prepare for court proceedings. It is save litigation costs and improve litigation efficiency. Through the review, cases that should not enter the trial stage of the court are excluded, which can not only save the national litigation resources but also reduce the litigation burden of each parties. The nature of the judicial review of criminal suspects is that the review does not resolve whether the defendant is guilty in advance, but rather determines whether there is a criminal suspect, which means whether there is an appropriate and reasonable basis for the accusation against the defendant. There are two types of review. One is the trial filter type. The objects filtered by the judicial review process include cases and evidence. Through this filtering, many misdemeanor cases or cases that do not meet the court criteria or conditions, such as insufficient evidence, are stepped before the stopped before the formal proceeding even begins. Second, the public prosecution review type of the Anglo-American law system uses a neutral third party to review the legality of the prosecution as a party from the evidence, focusing on protecting the defendant and avoiding groundless prosecution. At the same time, various countries have different regulations on the on the organization content, specific procedures and processing after the review. This article does not discuss all this in details. However, no matter what type of judicial review of public prosecution standards, it is a transitional stage connecting public prosecution and trial. The control of the neutral judicial power over the public prosecution power protects the legally innocent defendants. And the protection of the human rights of criminal suspects and the defendants in criminal proceedings is a valid extension of international human rights theory and constitutional practice in criminal proceedings. It is the development trend of the system of criminal proceedings. The principle of presumption of innocence is to put into practice throughout the entire criminal procedure. The establishment of each litigation system is premised on the principle of presumption of innocence. First of all, criminal aspects and the criminal facts should be distinguished, and the formulation of legislation should be more and more strict, standardized to avoid the misleading. Secondly, in judicial practice, criminal cases should always be handled from a presumption of innocence perspective, and we should always be vigilant to avoid treating criminal suspects as criminals. Thank you.